Please be seated. Good morning. We are here today for oral argument in our case number, in RGS Diamonds v. Tal Designs, our case number CV22 0185. Each side has 20 minutes for your argument. The appellant may reserve time for rebuttal. We don't keep that up here, so there's a clock over there for you to watch and keep it yourself. Our proceedings today are being audio and video recorded, and live streamed. And if you can introduce yourself and your client, it would be appreciated. We've read the briefs, discussed the case at conference this morning, and are familiar with the arguments raised. So if you can keep that in mind when you argue, it would be appreciated. And with that, counsel, you may proceed.
Thank you, Your Honor. May it please the court. Good morning. Greg McGill on behalf of the appellant, RGS Diamonds Limited. There are essentially three issues that I think are pertinent for your honors in this appeal. The first is whether the trial court abused its discretion in ruling several months before a third trial was set in the case that there was a failure to prosecute because an approved second amended complaint against the individuals by the trial court was filed 15 days late.
That's what the rule requires, the amendment be filed within 10 days, I think.
Yes, you're correct,
and
Judge.
The time has expired by the time that your client filed that amended complaint. So how did the trial court abuse its discretion?
I'm sorry, Your Honor.
Yeah, if as you concede that the amendment was filed outside the 10-day limit, how could the trial court have abused its discretion?
Well, the reason that it abused its discretion is because the discretion is not without limits, is my first answer. The second answer is that the whole body of Arizona law, and this is mostly in the area of disclosures, for example, if there's a late disclosure, and sometimes in discovery, for example, if there's a late request for admission. There's cases that I cited, in particular in my reply brief, that uniformly hold that if there is a technical transgression, because we're all subject to error, we're all subject to mistakes, that if there's a technical procedural transgression, that does not necessarily defeat the client's right to have substantive rights and determined on the merits.
So what I understand you to say is that even though the rule says 10 days, there's still a hard and fast rule as long as nobody's hurt. Is that basically your argument?
Well, as long as no one's hurt, and that goes to the issue as to whether there's prejudice, and the answer is yes. And the reason that particularly the prejudice component should be given particular weight by the Court of Appeals, even with the abuse of discretion standard. And I recognize it's not de novo. I recognize that. But even with that standard of abuse of discretion, which I said is not unlimited, even with that standard, from a policy standpoint, under the Rule 15 is there, which says 10 days, it's there for a reason, but it's there typically in most cases, if not the great lion's share of the cases, 90% of the cases, amended pleadings are done in early stages of the case. Here we have the exact opposite. Here we have a case that was filed in 2018, and this Rule 15 call by the trial court was made in 2022, 4 years into the case, and 2 years after active discovery concluded in 2020.
Does the rule say it's 10 days unless no one is prejudiced?
The rule does not mention prejudice, but the Ninth Circuit case has ruled, it's a Ninth Circuit case.
But we're not in the Ninth Circuit, we're in state court.
Well, we're in state court, we're not in federal court, but for purposes of I think it's instructive. I think it's instructive to go to a Ninth Circuit case, Your Honor. And incidentally, I have two answers to your follow-up question. One is the Ninth Circuit case that went through 5 factors in the context of Rule 41, dismissal for a failure to prosecute. Because, and this ties into the 10 days that you're asking about. And I know your question was confined to the rule itself, but it ties in because the trial court dismissed the case on the eve of a third set trial, late in the procedural proceedings, not early. Rule 15, the 10 days, is early in the proceedings. There's a policy behind that to move the pleadings along and get the case launched. We have the opposite here. That's number one. Number two, in terms of prejudice, the court found in its ruling approving the second amended complaint, the court found in this minute entry, Your Honor, was November 16, 2021. It found that the defendant's claim they are now prejudiced, but the claims in the second amended complaint, this is the trial court, it's a finding. On the eve of trial, the third set trial, but the claims in the second amended complaint are exactly the same as the claims in the amended complaint filed on March 3rd, back in 2019. Discovery was over in 2020. There was nothing to prosecute. Back to the minute entry. No new parties have been added. The claims against defendant Tal Barkle personally are now fleshed out more definitively. This should be a benefit to the defendants as the claim is now clearer. So the court found there was no prejudice. The federal case in the Ninth Circuit, and I understand we're in the state court for sure. I understand that. But in the Ninth Circuit case, Your Honor, which I would make an appeal to the court for instructive purposes, the case is Applied Underwriters, Inc. versus Lichtenegger, 913 F. 3rd, 884. It's a 2019 case, and it deals with Rule 41, dismissals for failure to prosecute. They moved on a failure to prosecute. There was no failure to prosecute, and the record does not support that. That's what makes it an abuse of discretion, because the court found there was a failure to prosecute as a result of the 10 days, but there was no failure to prosecute.
Because I thought that the ruling was for the 10 days, not for a failure to prosecute, but my reading of the minute entry, the basis of the court's ruling was that the amended complaint wasn't filed with an improper time limit, not because, not under Rule 41 for failure to prosecute. Perhaps I've misread that minute entry.
Well, Your Honor, the court said that I missed the 10 days. The court said that. You're correct. But the motion from the defense went in They framed the motion as a failure to prosecute as a result of missing the 10-day procedural rule. Again, that procedural rule being applied on the eve of a third trial, as opposed to early.
But the trial question got bound by the name of the motion or any particular argument made within that motion.
I interpreted the court granted the motion, which is a motion for a failure to prosecute. The record does not support a failure to prosecute, and for that reason, it was an abuse of discretion. The case on abuse of discretion.
So we have to accept your assumption to buy that argument. Is that accurate? You're assuming the decision which said it's based upon the 10-day requirement of the rule that the decision was based on a failure to prosecute rather than just sort of a failure to meet a deadline under the rules. If we find that it was just a failure to meet the deadline under the rules rather than sort of this non-prosecution, do we still, does your argument still ring true?
I think our argument still does ring true, Your Honor, with all respect to the panel, and for this reason. All the cases that I've looked at in this area, whether it deals with good cause or excusable neglect, all of the cases in Arizona and the Ninth Circuit both are uniform. They say that the overriding principle is to have an adjudication on the merits and not have a technical transgression on a procedural rule trump a substantive rights for the client on the merits. It's a key axiom in the law. It's consistent throughout all the states, state and federal law.
Well, we also have axioms that we follow our rules.
Well, that's true, and I'm not asserting for a second that I shouldn't have missed it, and I did miss that. But what I'm asserting is that the client should not lose substantive rights because the attorney missed a 10-day rule. Now that, in other words, there are lesser sanctions. Back to the federal case, the Ninth Circuit case. This is the applied underwriters. It went through the 5 factors. So it's not just my argument. There's 5 factors that the Ninth Circuit, forgive me, I know we're in state court, but it's instructive. It goes through and it says, under a dismissal, which this was. It was a dismissal of the individuals, the Second Amendment complaint, on the third reset trial, 4 years in, when discovery was over for 2 years. And the court found, when it allowed the Second Amendment complaint, that there was no prejudice because the Barkles individually had been in the case originally. So they weren't surprised. They were in the case originally, and then they were out because Judge Wiley had dismissed based on an alter ego, and Judge Sinclair rotated in. She didn't know. She wasn't sure what the meaning of his ruling, whether it applied to the individuals or not. We lost time there. Then there was COVID, and I missed the 10 days because at that time my office was closed during COVID. I'm also high risk because I have a cancer condition. So those are some exigent circumstances that I think the court should not overlook. But the factors are the public interest and expeditious resolution of the litigation. We're 4 years into the litigation on a third reset trial that I didn't have any control over. In fact, there was a certificate of readiness in 2021 that both sides signed in 2021 and filed into the record. So there's no failure to prosecute. There's no dilatory conduct on my part. No dilatory conduct. And so that, the public interest and expeditious litigation, the other factors, real quick. The courts need to manage its docket, which Judge Weinswag, you just mentioned, that's obviously an important consideration. The risk of prejudice to the defendants, there were none. The court found there were none, and there were none. The public policy favoring disposition of cases on the merits, that's a very important one. And the availability of less drastic alternatives.
Mr. McGill, let me ask you on this. First
yes,
of all, I'm very happy you're
Sure.
doing much better, it appears. So
Thank
happy
you, Your Honor.
for that.
Thank you.
Is the dismissal a sanction? I think you called it earlier a sanction. Is it a sanction? And if it is,
Yes.
what would be an example of a less severe sanction?
And that's where I was going. That's where I was going. And that was the 5th factor. Less drastic sanctions should always be considered. I think the dismissal is a sanction because the client lose substantive rights when the individuals the court in late 21 approved the Second Amendment complaint against the individuals, found there was no prejudice, that Second Amendment complaint, the individuals had been in the case earlier, there was no surprise, and that there was no prejudice because it was basically based on discovery that had been conducted in 2020, and discovery was over in 2019, but for the depositions, because both parties stipulated we could go beyond Judge Wiley's scheduling order and take depositions in 2020. But the less drastic sanction could have been attorney's fees, against the plaintiff or counsel. Attorney's fees could have been issued to send a signal, follow the rules, shouldn't miss the 10 days. I'm not up here saying that I, as counsel, should get a pass in some way. I'd be willing to, if I had to pay an attorney fee for that, missing that 10 days on the eve of the third set trial, I think that would have been appropriate. I don't know what amount would have been appropriate, but the last thing I'm doing is making an appeal to the court or suggesting to the court in any way that the rules should not be followed. That's not my argument. My principal argument is try the case on the merits, no prejudice, a lesser sanction for missing the 10 days was available, and the merits on behalf of the client not losing substantive rights in a case that had been continued several times, 4 years in, and both parties for a year or more had certified that it was ready for trial. There was no failure to prosecute and to remove the substantive rights from the client, I think was an abuse of discretion.
Counsel, I take it you argued to Judge Conley and Judge Sinclair that the other side was not prejudiced by your delay?
I argued that in a Rule 59 motion for relief from this dismissal of the individuals and dismissal of the Second Amendment complaint, but she did not. She denied the motion without comment.
And the reason that I ask, though, is we're a court of review. We're in a court in the first instance. You're making very factual arguments about, about no prejudice, and the trial judge is in a much better position to make that call than we are.
They are, but she didn't make that call. That's part of the problem, and that's why there should be a reversal. She didn't make that call because an abuse of discretion under City of Tucson versus Clear Channel Outdoor, and that's 218 Arizona 172, it says there's different ways that a court that does not have limitless discretion can abuse that discretion. In one, if there's an error of law, and the other is if the ruling or the conclusion by the trial court is inconsistent with the record.
Well, I guess that's my point. Is you made the argument that you're making today to Judge Sinclair. Although the judge didn't say anything, she denied your motion, which indicates to me she wasn't persuaded.
Well, she denied the motion, Your Honor, but she never reversed her prior ruling. This is what makes it an abuse of discretion, because the record, she established a record in my favor on this issue, because on November 16, 2021, she allowed, just a month or two before this ruling that we're talking about in late 21, she found that the Second Amendment complaint against the individual should go forward because she found that there was no prejudice. But she didn't turn around a month or two later on this procedural transgression of the 10 days on the eve of the third set trial. She didn't find all of a sudden that there's prejudice. She just denied my Rule 59 motion for relief without comment. She didn't reverse her prior. So the record does not support her dismissal of the Second Amendment complaint. Her own record doesn't support it.
Thank you.
Thank you. I'm going to reserve 5 minutes. Oh, thank you.
Well, you have a minute 42.
Okay, before my last 5?
Just a minute
okay.
42.
Yes, and I'll come back. Thank you.
Count.
Good morning, Your Honors. Ira Schwartz with Parker Schwartz on behalf of the defendant appellees Tal and Dana Barkel. Your Honor, I think the only question really here is whether the court abused its discretion in denying Rule 59 relief and ultimately dismissing the plaintiff's second amended complaint.
Would the court have abused its discretion had it denied the motion to dismiss to begin with?
Pardon me, if it had denied the motion to dismiss?
The request to amend the second amended complaint, if the court had allowed that late amendment more than 10 days after the court issued its order allowing the amendment, would the court have abused its discretion if it had allowed a late amendment under the rule? The rule says
Yes,
10
Your Honor,
days.
the court has discretion,
right?
so I guess it works both ways.
Right.
It could have allowed it, it could have imposed some lesser sanction, as Mr. Miguel suggested, and it could have dismissed it. As a matter of fact, if you look at the entire record, I know Mr. Miguel is arguing that this dismissal was overly drastic under the circumstances, and one of the factors that's in the test in that applied underwriter's case and in the Urish case, this test is the same, we've cited to the Urish case, is whether the court considered less drastic sanctions. And in this case, if you look at the record, not only did the court consider how drastic this was, but it actually went farther shortly after it ruled on this and dismissed the case in its entirety based on the Rule 59 motion and its inherent review. And then when plaintiff filed what they called a motion for clarification of that judgment, which the court considered a motion for reconsideration, it did reconsider its ruling and applied the dismissal only to the individual defendants and allowed the First Amendment complaint to go forward. So in terms of a less drastic sanction, this was the less drastic sanction because the court did go even farther and then on review took a step back to allow this. I think the court has broad discretion. The case law says it has broad discretion if there's a violation of the rules or if a plaintiff fails to move forward with the case. Rule 41, under which this was granted, applies that the court can dismiss a case for failure to prosecute or for a violation of the rules. There was a clear violation of the rules. The plaintiff had 10 days to file its amended complaint. It didn't do so until 15 days later, 15 days after its deadline and run, 30 days after 29 days after the court had granted its leave. And only after the defendant filed a motion to dismiss, then they went ahead and do it. Clearly, Mr. Miguel missed it, totally.
So the basis of the court's ruling was a violation of the rule, not for failure to prosecute more broadly.
Your Honor, I think under the facts of this case, both apply. You also should look at the facts of the case. The second amended complaint was filed 15 days late. Probably procedurally should not have been permitted to file because once the 10-day window closes, if somebody wants to amend the pleadings, especially this late, they have to get leave of the court. While leave was given, that leave is open for 10 days under the rules. If not, that had run. And this is especially egregious in this case because the individual defendants were originally dismissed in this case back in 2019 when the First Amendment complaint was filed. Judge Kiley, and I believe plaintiff referred to him as Judge Wiley, but I'm pretty sure it's Judge Kiley, had a hearing on a motion to dismiss the claims against the individual defendants, granted amended entry dismissing those defendants. That issue was then at least made clear later in the case when there were summary judgment motions. There was an explicit reference by the defendants in response to the motion for summary judgment because there was reference by the plaintiff in the summary judgment motion to the individual defendants. We made an explicit paragraph saying those individual defendants were dismissed way back at the beginning of the case. At no point after, and it's incredibly important to note that when Judge Kiley dismissed the individual defendants early in 2019, he gave plaintiff leave to amend to fix the issue. They didn't file an amended complaint at that point. And just for clarity's sake, plaintiff filed an original complaint, and then prior to the answer being filed, they filed a first amended complaint. So it was the first amended complaint from back in 2019 from which these individual defendants were dismissed. In that, also early on, there was reference to Rule 15 and the time limit. So plaintiff's counsel has been reminded repeatedly of his obligations and this 10-day rule. Despite that, they missed the 10 days and not even close. I know plaintiff's motion referred to our motion to dismiss or fill the process as a gotcha motion. We did not file that motion on day 11. We waited, a substantial period of time. We understand things happen, but instead of filing it within 10 days, 29 days later, defendants filed a motion to dismiss, and it was only after that was filed and they were reminded that they then filed it. Given the number of repeated attempts that they had to cure this issue and the very long length of time under this, Judge Sinclair decided that it was appropriate to dismiss the claims as to the individual defendant. And I should clarify, although it's styled as a motion to dismiss under the rules, what really happened was the individual defendants have been out of the case since 2019. This would be bringing back new defendants to the case on the eve of the third trial. And so, the court didn't buy our arguments as to prejudice, but there is, I believe, some prejudice to the defendants. Now, admittedly, it's not great prejudice, but if we go forward now, if the individual defendant, if the second amended complaint is now allowed to stand, the defendants are now 6 years, we're going to be close to 6 years from when this transaction occurred, going to have to go back and either spend the time and ask the court for time to file procedural motions because the defense is confident that a lot of the claims won't survive a motion for summary judgment, which would put this case off even longer, or waive that and go to trial on everything just to get this case brought to trial. I think those are some of the factors that the trial judge, she wasn't explicit, but looking at the record, it appears logical that those are some of the factors the court considered in exercising her discretion to dismiss the second amended complaint and allowed the case to proceed only on the first amended complaint as to the corporate defendant. The other, one of the factors to be considered in exercising the court's discretion is the actions of the plaintiff, and if there is, I think we're a little procedurally, I had some questions here. Plaintiff has argued repeatedly about excusable neglect because of his health issues, but he filed for relief under Rule 59. Rule 59 doesn't include an excusable neglect standard. Rule 60 does. They didn't exactly file it under Rule 60, but rather under Rule 59. But even if you apply an excusable neglect standard, I give credit to counsel that I'm sure he had some health issues in there. The court under the I think it's Walker versus Kendig case said even if there's health issues that affect the case, the court can do an ad hoc review of the extent of those health issues and how they affected plaintiff's counsel and his ability to do his job. And in this case, we've asked the court to take judicial notice. Mr. McGill, during that 29-day window when he had to file this, was actively engaged and participated in another case, Miller versus Osvath, which is a trial court case. He filed multiple motions, had a final pretrial conference, and actively participated. So the extent of his health issues at least allowed him to actively participate then, and I believe it should have allowed him to do something on this case. Plus, the excusable neglect standard says counsel must act in the manner of a reasonable and prudent attorney. Under these circumstances, we submit that a reasonable attorney who has a health issue that's going to affect his ability to proceed with the case, that a reasonable step would be to ask for an extension. First of all, I don't think that the burden on the plaintiff was that significant. He was given leave to file a first amended complaint. He attached, a second amended complaint The draft Second Amendment complaint was a red line version, which is required by the rules, was attached to his motion. So it's a relatively straightforward task to convert that to final form in accordance with the judge's ruling and filing it. But even if he didn't have the ability to do that, he should have had the ability in some way to either reach out to opposing counsel, request an extension, or file with the court to request an extension due to his health issues.
Counsel, why shouldn't we accept applied underwriters in the Ninth Circuit?
The test for applied underwriters is the same test in Urish. We've argued that same test. There's 5 factors to be considered under that test. Prejudice is only one of those factors. The other factors...
Why don't we come to the same conclusion, I guess, which recall you saying that applied?
Well, Your Honor...
Well, why is this case different?
I'm not sure this case is different. The question is, did the trial court apply those factors? And they're not required to make explicit findings. If the record is clear and it supports the trial judge's discretion to do that, this falls within the trial court's discretion. So I would...
So what was it that was animating the discretion?
All the factors in terms of the timing of how many times we reviewed this issue of the individual defendants, the First Amendment complaint, the fact that it was dismissed, and the delay, those factors include the court's ability to control its docket. Clearly, the trial judge was trying to get this case to trial. And the easiest way to get this to trial under the fact that the plaintiff violated the rules was she determined that to strike the Second Amendment complaint and allow the case to proceed on the First Amendment complaint. That's a legitimate judgment that the trial court can make. The public interest in expediting litigation, that's a factor. Clearly, I believe that's consistent with what we just talked about with the other thing. There is a fact, one of the factors is favoring decisions on the merits. You've heard a lot about that, but that's not the only factor. And the final determination factor is did the court consider less drastic alternatives? As we've discussed earlier, this court did, at least at one point in time, entered a more drastic remedy by dismissal of the whole case, and then on reflection, reduced it to this. So I think there's a clear, that record clearly reflects the judge considered those less drastic factors and determined that this was the appropriate remedy in this case. And she has the discretion to do that. There's an admitted violation of the rules. And under all the factors here, it looks like she exercised her discretion. This court should uphold that discretion under the case law unless there's an absolute clear case that she violated that. I think the rules allow it. Case law allows dismissal of a case for violation of the rules, especially in a case that's not being actively prosecuted. And you should uphold the court's discretion because she exercised her discretion and she gave a permissible result. Thank you, Your Honor.
Thank you. Counsel.
How much time? Okay. Thank you, Your Honor. Okay, going through the factors on the underwriters, Your Honor, the first factor, expeditious resolution of the litigation. Number one, with all due respect to defense counsel, Judge Sinclair did not really come into the case until 2021. So in 2019, she was not in this case. This case went for over 4 years. There was no dilatory or failure to prosecute on my part, nothing dilatory. I was done with discovery in 2020. When COVID hit that summer, we took the depositions. Discovery was over in 2019, according to Judge Kiley's scheduling order. The only thing that was left, pursuant to stipulation, counsel didn't tell you this, were the depositions. They were done in the summer of 2020. We both submitted a joint trial readiness it was on August 3rd of 21. This is August 3rd of 21, a joint certificate of readiness for trial. I didn't delay this case. I was not dilatory. All the discovery was done. Discovery was cut off by Judge Kiley in 19. Depots were finished in the summer of 20. Joint readiness for trial in August of 21. The trial was reset 3 times through no fault of my own. because of COVID and scheduling in the court system. So none of what you were just told, none of that is true. That's what's amazing right now. And so expeditious resolution of the litigation, this is underwriters. Courts need to manage its docket. I did not interfere with the court's management of its docket. The court found there was no prejudice in her ruling allowing the Second Amendment complaint against the individuals and never reversed that. The merits, ruling on the merits, should trump everything. That's factor 4.
So do you wind up, counsel? You're just,
Sure,
you're
yes,
out.
Your Honor. Thank you.
Wait, wind up.
And then less drastic. Again, an attorney fee, don't do that again. We have a trial in 3 months. You pay the fee. There were no less drastic sanctions were even considered by the court. Nothing was considered. That's what the abuse of discretion is. The client should not lose substantive rights for a technical transgression on this record, this particular record.
Thank you, sir.
Thank you. Thank you, Your Honor.
Okay, well, we will take the matter under advisement, have a decision issued in due course. We are not going to adjourn. We're going to wait for the next folks, the next lawyers to set up. But thank you for your argument.